back to the show. This is The Law Show on CL 650.
We can work it out. We can work it out. Life is...
And welcome back to The Law Show on CL 650. We're talking about wills and estates. We have Alyssa Lockhart here from McQuarrie Hunter and Leah Donaldson as well. Now, we talked before the break about you were named as an executor in a will, but you weren't aware of that. Is that a common problem, and you really need to let these people know that if I pass, you are going to be in charge of dealing with this? Is that a common problem?
It happens. I wouldn't say that it's as common as it used to be. I think now consumers are far more informed. We're also far more open as a society. So it's a very private document. It's your private plan. But it used to be shrouded with far more secrecy. Now people leave our offices very comfortable knowing that, and part of it is education. Our job is to educate the clients, but they leave our offices knowing that they need to discuss this with their executor. They need to ask for permission to name someone to such a high appointment of responsibility. Mm-hmm. So it's less, but I still see that it does come up.
Now, someone in a different area of the country, like mm-hmm. someone in Toronto or Montreal, is it wise to have somebody local?
It's very helpful to have somebody local, depending on your asset base. If you don't have a lot of personal assets, if you don't own real property that you're living in that needs to be secured, it can be easier. So if you're pretty much liquid at the time of your passing, if you've lived in a care home, if you've downsized significantly, if you've already gifted your assets, then it's less of a challenge. But I wouldn't say that geographic distance precludes someone from being a good executor. I would say that it is very challenging if someone who is geographically distant, has a busy life of their own, doesn't know that they are the executor mm-hmm. prior to your passing. The
actual will itself, where do you put it and how do you let people know where it is? I'm sure this has come up where there's a previous version. Well, by the way, there's a newer version. Like, how do you have a file on it, I'm mm-hmm. sure. So do you just say, this is my lawyer, go and see mm-hmm. them to get the latest version? How do you deal with that?
Well, we do have a policy that we store without charge original wills, mm-hmm. and that used to be very common. It somewhat goes in and out of favor. It is an expense to law firms, but we don't pass it on to our clients because for our view, the client potentially losing the will being absconded with if it says something that individuals don't like. Yeah. The will being destroyed accidentally. I had one client one time who threw their wills out. His wife had rolled them up and put them at the back of the freezer, and he thought they were phyllo pastry. She came in and she said to me, "Have you ever seen phyllo pastry so short? He doesn't know anything."
Why is your will in the freezer? That's the first question.
People put their will in the freezer because it won't burn down when their house does.
Oh.
Right?
There you go. I just learned something.
Right. This is the belief.
Right.
So we do store wills. We don't charge for the clients to leave them with us. But when we give out our package at the end of the process, I include 2 of my cards, and I include 2 of one of the associates in my department's cards, one of the solicitors, not Leah because she's in litigation. But we want to make sure that they're able to give cards for the firm to their named beneficiaries, to their children, to their executor, to whomever they feel it's appropriate, who will know immediately upon their passing and who will be able to get in touch with us right away.
Okay, so let's get into some of the scenarios. Previous marriages. Obviously, you divorce somebody, you're coming into a new marriage, and you have children from different marriages together. So how do you then decide how you're going to separate assets at that point? Mm-hmm. What do you typically see?
Well, that can be a solicitor's drafting question, that can be an estate litigation question, and it can be a family law litigation question.
It can.
But one of the things that I think Leah might look at is valuing the assets that grew after and subsequent to the second marriage. That's something significant for you, isn't it?
It is, yes. So that's one of the questions to do with family law, being that under the Family Law Act, the
And is that
family-
why you wear those two hats? I mean, they do go together,
There
right?
is a lot of overlap. There's quite a bit of overlap. So the asset that comes into a marriage is protected under family law legislation as an exclusion, but the growth on that would be considered family property. And so sometimes when we see with blended families, we have people that they're not getting separated, right? It's a passing usually that we're dealing with estate litigation. But there's different, the legislation applies to vary someone's will if you're a child or a spouse. So that would include your children and any adopted children.
Can you give us an example what that means?
Yeah, so for instance, a will maker might make their will and they decide to leave everything to their children and nothing to their spouse for whatever reason.
Right.
If they have not gone to a good estate planning lawyer who is going to explain the law to them, they might do that and not understand that there is a section in WESA, the Wills, Estates and Succession Act, that allows their spouse to apply to the court to vary their will because they do have an obligation to make just, adequate, and equitable provision for their spouse and their children. But one of the complicating factors we see with that piece of legislation is that it doesn't apply to stepchildren. So, for instance, a will maker might, they have 2 children and the other party has 1 child. They get married, they build up an asset base, but they leave everything to their spouse. Their entire, all of their property is going to pass to that spouse, and their child doesn't have a claim against that spouse's estate when they pass away because they're a stepchild.
Why would that be?
Well, the legislation precludes stepchildren from making that application because they do not have the same relationship with that deceased person as a natural parent would in the eyes of the legislation. This is
Even though they might have lived with them for 20 years. Right?
Exactly. This is one of the areas that I'm most passionate about. I hear a lot of clients say, well, we did our will on our own, or we went to someone who didn't specialize because we just wanted a simple will. We wanted to leave everything to one another and then to the children after the passing of the last of us. Absolutely. I agree with that. I want that in my will as well, but I'm a member of a blended family. And I'm the product of a blended family. So that's why I love this topic.
Okay.
I think everybody should know as much as they could possibly know about it. My husband and I have 3 children, and he has known my oldest child since she was 3. And he's really her dad on a day-to-day basis. Even though her biological father is still in the picture and we're all good friends, he is raising her. So we want our assets to flow back and forth to one another, because if something happened to me, he would continue to raise her. And she would stay with our family unit, even if I passed on. But let's say that I pass away the year that she moves off and goes to university. My husband's a little bit younger than me. He decides to remarry, because that happens. So let's say that he remarries someone a little bit younger than him, and she has children, or she wants to have more children with him. My child is now out in university, she's gone off into the world. Maybe she doesn't get along well with this stepmother who was never in the role of a stepmother. So she comes home less frequently. She starts seeing her biological family more frequently. She falls away from the family unit. 20 years from now, is my husband's second wife going to say, when we die, what should we do with Alyssa's money? Or is she going to say, when we die, what do you want to do with our money? It's no longer my asset in their minds. They've been the custodians of it. They've been using it for their purposes, which is entirely what I want my husband to do. But my daughter will not have a claim against their estates. When they write her out, she will be written out, and she will not have the potential to vary. So what I need to do in my estate is I need to protect something for her, or I need to ensure that the drafting of our 2 wills between my husband and I ensures a mutuality, a contract, as it were, that he will not strip his estate of assets and that he will not remove her as a beneficiary after my departure. So, and Leah sees a lot of that, I would suspect.
We do, absolutely. And people don't necessarily understand that a stepchild would not have that right. And so they're not looking 20, 30 years down the road, because you can't anticipate all of that unless you go to a proper lawyer who can say, I can, look into my crystal ball and give you all these different scenarios that might happen and explain what might happen if, A scenario happens or B scenario happens, to give you that guidance.
So how often should you update your will? It sounds to me that things can change regularly, and that's when you need to do it.
I think that you should always update your will when things change. You should probably read your will every 3 to 5 years is the industry standard when we're speaking with people. If your family structure changes, take a look at your will. If your intentions change, take a look at your will. If your asset structure changes, take a look at your will. And if your location of residence, if you become a resident of another legal jurisdiction, that's another issue that might change. So any type of circumstance. But one thing I wanted to ask Leah, though, is do you find that because of WESA not allowing stepchildren to sue on the other parent's estate, would they be more inclined now to, without any family strife, would they have to sue within a time period of their own parent's death if their parent dies first?
Yes, we do see that. So they're trying to anticipate the fact that they won't have a claim later. And so they will, we do see, spouses and children suing one another after, say, the father dies or the mother dies, because they're worried that if they wait, they won't have that opportunity to vary the later parent's will.
Fascinating.
So from a planning perspective, I have assured both my oldest child and my husband that she will not have to sue her dad within a few months of my passing.
Right. Because when that spouse passes, then it's all over, right? You can't go back.
Exactly.
Right.
That's fascinating. That's why you need good lawyers to get it set up properly the first time.
That's exactly right.
So how many variations of complications of these things can you lay out in front of people when you have these situations? You say, well, this can happen. So many different variables.
As many as we can cover before my next appointment begins.
Good answer. We have Alyssa Lockhart here from Macquarie Hunter and Leah Donaldson, and we'll continue our conversation about wills and estates next on CL 650.
There's more of the show still ahead. This is The Law Show on CL 650.